And yes, it's great to see everybody again. Thank you so much for literally all around the world. Some of you guys are up at 3 a.m. Some of it's, for me, it's 8 a.m. Others, it's dinner time, afternoon. So it's incredible. Thank you all for being here. I am truly a big fan of you all who are taking this opportunity to take this course and learn this important information. So without further ado, I will hand it over to Dr. Harrington for today's session.
Thank you very much, Shellen. I will share my screen again if I can figure out how to do that, which I can. It just takes me a little time. Lovely to see all of you back, and any new faces, you are indeed most welcome. It really is so humbling to have so many of you here. And thank you. I had so many notes after our first session, so thank you very much for all the notes and the commentary. It was really appreciated. And I'm hoping that this continues to be something that you all enjoy. And you can also laugh at me as I try to figure out how to put this into, there we go, presentation mode. There we go. A few things just I think before we begin. There will be translation, as Shellen mentioned, at least with French. So if there are questions, obviously please do refer to the translation. If you want to put questions in the chat, certainly for French and for Spanish, we have people who can translate that quite quickly. So that's fine, and I can certainly translate it myself. That's perfectly fine. For those of you who are coming in, please come in, welcome. For those of you who are having dinner or about to, please have dinner, have breakfast, have lunch, make yourselves comfortable and listen and hopefully enjoy a bit. And just to point out, because of some of the time differences or the global nature of the boot camp, many of you will be perhaps changing times this weekend. So if you are in one of the time zones that is changing, that has not already changed, we'll use the UTC. So whatever the UTC time is that is listed, for example, today is listed at 3 p.m. We'll use that time for our next sessions. So please do kind of consult that. And obviously, if there are questions, please do let us know. If you are not in one of those time zones changing this weekend, then do enjoy the hour of sleep you are not losing in the process. And also a quick reminder, and I'm sure Shellen will jump in at the end as well, just to point out that the ways in which we've structured the course include not only the 2 sessions that we have during the week, but also the opportunity and the option. So absolutely not required at all, and not connected to any certification or anything, but the option to join us on Saturday, at least UTC, and I know in Sunday in some of your time zones, for a discussion section. So what we'll try to do is get through as many questions that might come up today during our course, during our session. But if there were questions that we couldn't get to from last time, we will look at those, and then we'll also look at leftover ones from today on Saturday or Sunday, as it were. And then we will look at the questions that also come up. So if you have a chance to think about things that we've learned and that we've touched upon and want to, for example, ask a bit more once you've had a chance to digest it, then this is also a chance for you to do so as well. But I'm sure that Shellen and the rest of the CYMG team will have lots more information for you in a bit. Now, Shellen, if there are any announcements that you want to jump in on, obviously just jump in and tell me. To remind us all, because it's only been 2 days, but a lot can happen in 2 days, especially in all of the worlds that we're living in. What we talked about last time in our opening lecture session was the idea of international law generally. So I just wanted to do a bit of a reminder and a refresh slide. Actually, not move back, move forward would be even better. There we go. On what we looked at in our first session. And so we reviewed a number of things. We reviewed the idea of what international law actually is, first and foremost. We also looked at how international law relates to states, which again, as a reminder, that is the formal language we use when we're talking about countries. So in the international law world, when you hear a reference to a state, we are referring to a particular country. Thus, when we hear things like a state party to a treaty or to a convention, this means that a country is actually a party, a member of a treaty or a convention. And when we get into the discussions later on in the boot camp about what comes from treaty negotiation processes, we will often talk about them as being state-driven processes, meaning they are driven by the countries that participate in them. We also talked about non-state actors and the potential for non-state actor involvement in the international law process, which is very different than the involvement of states, largely because states are considered to hold sovereignty in international law. And so that gives them the ability to create international law on a different plane, on a horizontal plane, if you remember us talking about that, rather than domestically, where they do it on a vertical plane. We also then talked about sources of international law. So where does international law come from? And also, not only where does it come from, but how do we give priority to different sources? Because there are multiple sources. We have treaties and agreements and binding instruments of international law. Uh, those are ranked the highest. Then we have customary international law, which states do because they believe they have an obligation to do, and they may suffer a consequence if they don't actually do or fail to do, depending on what it is. But there is no written treaty obligation for them. So that's ranked number 2, treaties, custom. And then we have general principles of international law. So things like the idea of non-retroactivity of laws. So you can't be prosecuted today in most legal jurisdictions and in international law for something that was not a crime today. If it becomes a crime tomorrow, then after tomorrow you can be, but in today it would not be. So that's, in a very simplistic way, the idea of non-retroactivity. And then also we talked about where cases come in, and cases, jurisprudence from any state court, national courts, also international courts, coming in as the 4th level, so the lowest level down of sources of international law, along with writings, such as academic writings that I do, to remind us all that because they don't have any legal effect, they are opinion pieces, they don't have the same binding nature in international law as sources. And we finally talked about the idea of enforcement in international law and touched on in particular where things like compliance committees and other compliance mechanisms in treaties come in as a way to create some type of international transparency mechanism and allow us to have a better understanding of how treaties may be enforced. So we did a lot. It was only an hour, but we did a lot, and we'll do a lot today too. And we will start today with the discussion of what is treaty law. Now, we talked about this a bit last time, and we talked about how you can, for example, look at the name of a treaty or the name of an international instrument and get a very good sense from its name as to what type of instrument it is. Is it a hard law treaty? Is it an instrument of soft law, etc.? So to remind you all, there are essentially 2 forms of international law instruments. So the first is what we call hard law. We often call it also binding law, a binding instrument. And then the second is what we would call a soft law instrument or a voluntary or non-binding instrument. It doesn't mean that if we have a soft law instrument, it has no legal value. It does. It will just be a different legal value than a hard law instrument. And it is very important to also remember that most hard law instruments, so most treaties, like for example, the Charter of the UN, which I decided to throw on there for some color, will have both binding obligations, so hard obligations, and also non-binding, so voluntary obligations within their terms. That is perfectly fine. And the presence of a voluntary obligation, a voluntary term in a treaty does not automatically make it soft law. What makes it soft law is whether is it intended to actually be binding on the states themselves, as a matter of law, whether it goes through a ratification process at home once it is signed off on. All of these things are very important for determining whether something is hard law or soft law. Um, as you may recall, I mentioned certain words that should give us an idea of whether or not there are hard law instruments afoot or soft law instruments afoot when we're looking at things. So words like agreements or conventions, covenants, these are all words that tend to be, or charter, but the charter is slightly different, tend to be indicative of a hard law instrument. Things like declarations, especially UN General Assembly declarations. Some things like guidelines, things like recommendations are often, more often than not, indicative of soft law instruments. So they won't go through a domestic ratification process. They don't have the force of binding international law, but they are still often reflective of customary international law. And as I mentioned, so here we have a visual of the Declaration, the Universal Declaration of Human Rights. Now, what I wanted to point out to you, and I know it's a very small version of it, but if you were to look at it, and those of you who have looked at it, you will see that it is a declaration. It is a very powerful declaration. And it came to us from almost the same time, very close in time, to the UN Charter, which created the United Nations. It created the International Court of Justice, and all of the different governance systems that we now know as part of the UN, or at least laid the groundwork and the foundations for them. That was considered and still is considered to be a piece of hard law because it has binding as well as some voluntary obligations, and because it is something that has to be taken home and ratified by the state parties to then be put into legal effect. And it allows, for example, members that ratify it to then become state parties to the UN. In contrast, we have the Declaration of Human Rights, the Universal Declaration of Human Rights, which is recognized as the foundational document for all human rights norms and treaties, certainly since the World War II era. However, it is a declaration. It is a statement of beliefs and statement of understandings by country members at the time, so by the international community at the time. And it has become the basis for a number of hard law instruments, for a number of treaties, a number of agreements, some of the most important human rights treaties, the covenants, and the conventions. So the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social, and Cultural Rights all come from this as a soft law instrument. And I wanted to highlight that to you because I think very often there is a case where people think that hard law instruments are the only ones we should be talking about or focusing on, but certainly hard law is important, but hard law often comes from soft law understandings. So this is why I wanted to point this out to you. The other thing to remember about a treaty, as I mentioned before, is that it is truly rare for a treaty to ever be purely hard law or purely soft law. Soft law is a bit easier to do in the sense that there can be most obligations under which states are encouraged, for example, or told they should, the language would be something like they should or they may do something. This is all permissive language, which is a soft law voluntary obligation, as opposed to a hard and involuntary, so binding obligation, which is something that we see with words like shall or shall not, or must not. So when you're looking at a legal text, again, a good way to look at it quite quickly and get a sense of whether or not something is most likely binding and hard law is to see the type of language used. And we will get to that, especially when we get to our discussion of the plastics treaty negotiations, to see what types of languages have been offered and what type of focus has been placed on different areas as either having binding potential language or voluntary potential language and what that might mean. But for now, just do remember that it is very unusual for a treaty to be especially entirely hard law. And even a treaty that creates binding obligations, such as any of the environmental agreements, the MEAs, the Multilateral Environmental Agreements, will have some elements that are voluntary. So there will be a mix of clauses that say a state shall do this, must do that, shall not do this, as well as saying a state should do this, or may do this, or is encouraged to do this, or commits to take steps to do this. So this is quite common, and it is something that is partially reflective of the real world of putting things into place, and partially reflective of the negotiations process that we'll talk about a great deal more over the next, now only 3 weeks after today. Anyway, this brings us to a question of what a standard treaty looks like, and especially what are standard elements of a treaty. And elements of a treaty might sound a bit formulaic, it might sound a bit scientific. There is a reason for that, in the sense that typically treaties, at least modern, and when we say modern, we tend to mean post-World War II. So we do tend to mean kind of post-World War II onwards. But most modern treaties have certain common practices and common elements within them. That's why we call them elements. Now, not every treaty will have all of these, and some it would be very weird not to, frankly. But some can be omitted, and there is nothing to do, with the legality of it if it is omitted, if that is a conscious decision. And there is a treaty that we will not talk about this time. We'll get into probably a bit more next week, called the Vienna Convention on the Law of Treaties. Some of you will likely have heard of this. And that sets a background. It's basically a set of default guidelines. So if a treaty is silent on something and there's a question about how to interpret that silence, or whether something can be done or not done under the treaty and it's not talked about, there can be a claim made, for example, to the International Court of Justice to evaluate the treaty under the Vienna Convention on the Law of Treaties, provided that the states that bring this claim are part of this system. And the argument would be whether a default rule would apply or not. However, we will get there in time. What we should start off with right away is what the common elements are, what the standard elements are in a treaty. So we have a number of them. I will just go point through this slide and the next slide quickly, and then we'll go back and we'll talk a bit about what each of these looks like, or what the point of each of these sections might be. Again, we could have a very long conversation on all of these. So if you have questions, or if you want a bit more information, obviously feel free, put the questions in the chat. And then if we don't get a chance to get to them today, we will get to them on Saturday or Sunday. And then if something does come up in your mind, between now and the weekend, then obviously feel free to ask it during that session. But there are, as I said, a set of common standard elements, starting with the preamble. And some of you may be familiar with preambles from either your previous work in international law or domestic law understandings. We then have opening provisions, so the beginning, the framing. Then we have control measures, which are highlighted in red because they are indeed often the most binding and voluntary or non-voluntary. So we'll get to those. We have voluntary measures. We have oversight mechanisms, compliance mechanisms, and the like. Then we have things like conferences of the parties or meetings of the parties. The designation of a secretariat or the creation of a secretariat, the idea of dispute settlement mechanisms outside the scope of the compliance committee, but in separate venues. And then also finally, the idea of entry into force provisions, which tend to be at the end, are easily kind of glossed over if you're looking at a treaty, especially if you're looking at a treaty for research purposes, but can be very critical in practice and can be very important in telling us when a treaty will become internationally an obligation and start to become binding at the international level. So really important, even if it's at the end. So don't kind of skip ahead. Is the general message. When you're reading a treaty, read the whole thing. But to go back and start with basics, what are preambles? What is a preambular statement? When you look at a treaty text itself, the treaty text will not jump into the Convention on Biological Diversity, Article 1, Article 2. Instead, you will see a number of paragraphs, typically, ahead of the articles. And these paragraphs will sound very often aspirational. They will start out with a number of different verbs, often statements like recognizing, for example, if we're talking about the plastics treaty potential drafts, recognizing the importance of plastic pollution as an element of the triple planetary crisis, reiterating the support of the international organization of states to address plastic pollution, for example, by highlighting the UN Environment Assembly Resolution 514 that authorized the negotiation process, and any other types of international law that might be relevant. And then explaining to those who are negotiating, as well as the international community, both of states and also of non-state actors, and for the future, what the motivations were behind the treaty. So the preamble really allows the countries who are negotiating to frame what the treaty was intended to do, why it was being created at the time, what the thought process was, what the intent was of the states who were negotiating it, and then also what other international obligations were considered and potentially could work in tandem with the terms of the treaty. So it's quite common, for example, to see a paragraph that is just a list of treaties and other agreements. So it can also include soft law instruments. For example, there are proposals for the plastics treaty draft to include reference to the Sustainable Development Goals, which are soft law, to the Global Biodiversity Framework, which is linked to the Convention on Biological Diversity, but the framework itself is considered to be soft law. And also, finally, I should mention, because it's so new, the Global Framework on Chemicals, which again is very, very new and also soft law. So all of these things will go into the preamble, as well as any other statements that may be important. So if there is a feeling, for example, that small island developing states are particularly impacted by plastic pollution, which many have advocated for and stated that they are, then that could be included in a preamble, for example, in order to explain that one of the motivating factors in creating this treaty is to assist small island developing states in trying to address plastic pollution, and that this is one of the background interpretive guides for the future that can be very powerful if we're looking at a court case, for example, in front of the ICJ, or even for future COP decisions, for Conference of the Parties decisions as well. Unfortunately, when I teach students, I often explain that the part of a treaty you may like best is the preamble, because it is lofty, it is elegant, it is a set of very powerful goals and understandings. Unfortunately, the part of the treaty that is absolutely not binding is also the preamble. So we have all these statements, we have all these positions to open and to frame, but they are not legally binding. Our legal obligations start, whether they are voluntary or whether they are hard law, they start with the opening provision. So typically Article 1 or Section 1, depending on the nomenclature. However, it should be pointed out that the preamble can be used, and indeed has been used, in a number of treaty systems. Recently, for example, the Paris Agreement, to allow the Conference of the Parties to create new programs, new focus areas, and start to incorporate elements in the preamble into their working obligations and their subsequent decisions. So, for example, if you're familiar with the idea of the just transition or just transitions themselves, that is an idea that is in the Paris Agreement, but it's in the Paris Agreement only in the preamble. However, after the Paris Agreement was adopted in 2015 and became operational the following year, it then was able to be expanded. So the Conference of the Parties was able to use the fact that there was a reference to just transitions in the preamble to start, for example, creating a just transition mechanism, to start having a committee structure looking at just transition, and to start figuring out how to bring this in more within the overall work of implementing the Paris Agreement. So including it in the preamble is actually a very important element, even if itself, in and of itself, the preamble is not binding. And I know I kind of labor a bit on the preamble point, but I like to point it out to people, especially as we're thinking about a treaty negotiation discussion, because often there is a feeling amongst advocates that if you don't get language into the main text, it is a failure, and if you get something only in a preamble, it somehow is a failure. And I would encourage everyone to think that any time you get any term into a treaty itself, that is a win, and even including something in the preamble is actually quite a win. So it can be very, very powerful. And then we get to the binding parts of the treaty. And so we get to the idea that we have the opening provisions. And typically the opening provisions will give us things like the objective of the treaty. What is the treaty intended to do? What is the meaning of the treaty? Why are we doing this? How are we thinking about it for the future? Then we also think about things like scope. So how will the treaty be applied? Is it intended to be a multilateral treaty? Is it intended to be a treaty that only looks at certain areas, and as soon as it comes into any potential overlap with other treaties, it stops? Or is it intended to work together with other treaties? And other issues like that are included in the scope. Typically, we have an objective and a scope. Again, these are not obligatory, and so it could be left out, but typically we do have that. And I mention this because when we get to the discussion of the plastics treaty, we will see that there is some debate on this. There also is a debate in the plastics treaty context as to whether we should include principles, but principles would be considered opening provisions. And principles tend to be very much guiding. So they explain to those who are reading the treaty for the first time, those who are at home trying to ratify it at the domestic level, and then also those who are seeking to implement it, and subsequent conferences of the parties as well, what the underlying core legal principles upon which the treaty was negotiated might be, and what everyone agreed should apply as principles moving forward. Many times you will see things like references to the Rio Declaration. Now, the Rio Declaration principles came from a time when the vast majority of you were not yet alive, not yet born. So it's been a while, but from 1992. And the Rio Declaration principles, which were adopted very close in time to the actual creation of the binding obligations under the UN Framework Convention on Climate Change and the Convention on Biological Diversity and the Convention on Desertification and Drought, set out a number of different principles that underlie those treaties and also the way that the international community understood international environmental law moving forward. So things like the principle of precaution, the principle of prevention, intergenerational equity, all of these things are considered to be under the heading of the Rio Declaration principles. So if you see a reference to that in the principles, that's actually what is meant, the whole set of principles. Sometimes we will see principles specifically articulated. So even if they fall under the Rio heading, we will still see them put in there anyway to make a point. So a reference to, for example, the polluter pays principle in the plastics treaty context has been suggested many times because of the inherent nexus with pollution. We also see principles and legal ideas that have subsequently been created or are outside of the Rio scope as well coming in. So proposals like including extended producer responsibility, for example, as a principle could also go here. And there are a number of different other options depending on who is proposing them that could go in the principle section. So that is an opening provision. And finally, what we see or what we hope to see in any treaty regime, which doesn't have to happen, but what we hope to see is the set of definitions coming into an opening provision. Now, I should point out again, and we'll get back to this in the plastics context later, in a week or so, that we don't have a functional set of definitions yet agreed upon for the treaty. And theoretically, we could have a treaty without actually having a set of definitions, but including definitions in the treaty makes it a much more powerful document in the sense that we can all understand at the international community level what we are regulating. So how do we define, for example, plastics? How do we define plastic polymers? How do we define the life cycle of plastics, etc.? All of these things which will be critical in terms that will be critical for implementing the treaty itself and understanding it are often subjects of a definition section. So that is just something else to think about that typically will be found in the opening provisions if it is there in the treaty. And then we shift, and we shift to what we call the control measures, hence the red coloring here, because it is a control measure. It is something that is typically binding, and thus it has a bit more legal force. And so this will be where we see typically the obligations for states to do things, to not do things, to design certain types of responses for regulations of chemicals, for regulations of plastic products, if we're thinking in this context. If we're thinking in the climate change context, we're thinking about obligations to either do things or not do things to address the climate crisis or not make it worse. To have nationally determined contributions. These are things that are in the control measures for the UNFCCC. To protect biological diversity and to protect trade in biological diversity, which is in some aspects of the different protocols to the Convention on Biological Diversity itself. all of these measures which have language like shall or must and make it an obligation, not a voluntary measure, are classed as control measures. So they come next. And they are followed by voluntary measures. Now, sometimes this is in the same part. So sometimes, for example, you have part one that has the opening provisions and a certain set of articles. You'll have part two that starts off with the control measures and then goes into the voluntary measures. Sometimes they're broken up. Again, it depends on the will of the treaty negotiating process. But the voluntary measures will be included as well. And sometimes these are things like aspects of reporting or national action plans, nationally determined contributions, national implementation plans, or elements of them, because we also do see in treaties that even when it is a requirement to file a national action plan, the terms of what must be in them can be voluntary, or it can be a bit more flexible. So we see these types of interplays often coming into effect in the voluntary measures section. Voluntary measures can also include things like capacity building, technology transfer, things where we see a bit more delicacy in terms of state sovereignty. So obviously there's a state interest in protecting to a certain extent some types of technology and technology transfer. But at the same time, if the treaty provides for technology transfer, the measures that will be used to express that are often voluntary measures. And I should pause here and apologize if there is construction noise in the background. It is coming from me, so I apologize. You know, you can create as much quiet as you want at home, but the outside world you have no control over. And I see some laughter, so I'm guessing some of you are hearing that. I do apologize. I'm sure as soon as I'm done, they'll stop too. The other thing on this slide to highlight is the use of a set of mechanisms for oversight and compliance. Now, we talked last time about the idea of creating a compliance committee or a compliance structure. Sometimes oversight also includes reporting. So reporting can be put in a voluntary measure. It can also be put in an oversight measure. And reporting is the idea that a state will have to, at a periodic time, file reports explaining how it has taken steps to put into place its treaty obligations, where there might be issues. For example, a lot of states, when they did their reporting for the UNFCCC and the nationally determined contributions, highlighted issues that they had in implementing things because of COVID. So explaining where those problems are, allowing us to understand where each country is, but then also to see where the global trends are and where there might be issues that need to be addressed by subsequent conference of the parties, et cetera. The compliance mechanism is something that typically will be in environmental treaties, some type of committee. It is typically, although it doesn't have to be, but typical practice is that it is considered a non-punitive system. So it wouldn't issue in that iteration, it wouldn't issue a legal determination saying country X has violated A, B, and C articles of a future plastics treaty and needs to make the following reparations or take the following steps. Instead, it would be a much less critical analysis, and it would be a finding that in the particular instance, state X had issues implementing certain aspects of its obligations under articles A, B, and C. And there are some recommendations for how it might do that in the future that could also then be used not only for state X, but also other states facing similar questions and similar issues as they move forward in implementation. So the idea is we don't use it as a court system. We don't use it as a punishment. We use it as a way to be helpful to the state itself and then also to others moving forward. And a lot of questions come up, and we will certainly talk about this in the plastics context, about who can refer matters to the compliance mechanism, how it will function, how it will work, who will be on it, and whether that is actually something that should be in the treaty, or whether the treaty itself should just create a mechanism and then have the conferences of the parties decide on what will go into that mechanism. For example, we see this in the recent Escazú agreement from the Gulak region on access to information in the environmental context and environmental defenders, etc. And then we come to the Conference of the Parties itself. Now, the Conference of the Parties, for those of you who are familiar with all the acronyms we use in international law, and there are many, so I apologize, is also known as the COP. Sometimes if we have, for example, a subsequent agreement or a protocol, etc., the Conference of the Parties may be called a meeting of the parties, and that is referred to as a MOP. Truly unfortunate names, at least translated into English. Unfortunate, but there you are. The Conference of the Parties is something that is the highest governance body of a treaty. So when a treaty is created and it goes into place, the idea is not simply we will have a treaty, everyone will be happy, go home, hopefully ratify it, and that's it. Instead, there is an understanding that you start a treaty, you start an ongoing process. And you start an ongoing process of legal engagement, social engagement, interaction and engagement between the states and civil society and observers, etc. So we need to have at least once every designated period, often it's every 1 year or every year or every 2 years, a meeting of the parties where they can come together. They will address issues that come up that are placed on an agenda, where we might need a further decision to clarify what something means, where we might need a further decision even in the treaty text, or told we need a further decision on, for example, the creation of an annex or what should go in an annex, on whether we need to amend a treaty or create a new protocol or a new annex, or even authorize new work for the Secretariat, which we'll get to momentarily, or authorize cross-treaty discussion. So authorize a discussion on various aspects of plastic pollution, but with the Basel Convention Secretariat as well, because there may be an overlapping issue of interest. So we want to make sure that these can be addressed holistically. So all of these things technically could fall under the Conference of the Parties. So there will be a governance part typically in a treaty. The Conference of the Parties will be there. And this is an important part, and it's important when we're creating a treaty to look at, because when we look at this, we see what powers the Conference of the Party has. If there isn't an articulation of something in the powers of the Conference of the Parties, it can't do it. So if the Conference of the Parties isn't expressly given the ability to create an annex, it can't do it. If it's not given the ability to amend the treaty, it can't do it. So that's why the Conference of the Parties creation and also powers are really important when you're looking at a treaty. And if you're looking at it to try to figure out what a COP can do or what it can't do, you want to look into that actual text. The same is very much true for the Secretariat. Now, the Secretariat will be a body that is created for the administration, so a bureaucratic body for the administration of the treaty. And it functions in a really critical role of overseeing the daily implementation of requirements for reporting, for country coordination, for planning the COPs, for planning various types of side event meetings, intercessional work, also where it is authorized to do so, things like engaging with outside consultants to generate its own reports and its own information, potentially liaising with other forms of multilateral environmental agreement or even other international treaty secretariats and bodies. So it has a great potential to be a very powerful tool for implementing and helping states to implement their obligations under whatever the treaty instrument is that we're talking about. But again, it's something that is created. And so when it's created, it has to be put in the treaty text, and it has to be given a set of powers. Otherwise, if it isn't given those powers, it doesn't have the ability to, for example, liaise with other international organizations and international organization staff, unless later on conferences of the parties give it that power. But up until that point, it doesn't have that power. Additionally, and I mentioned this is different than the compliance mechanism, there is the idea of dispute settlement. And this is something that's quite common. It's quite common towards the end of a treaty. And when we get to this, we're looking at what happens if there is a dispute between, say, two members of a treaty who are arguing over what an aspect of a treaty means in implementation, or one which believes that another state is directly in violation of one of its obligations, and can't go through the compliance committee, for example, because it's not something within the jurisdiction of the compliance committee. So here, typically what we see is a first effort to perhaps use the Secretariat as a means of helping to facilitate a negotiation or a dialogue or a mediation between the parties. And then if they still can't agree, the question is what comes next. Now, typically, it would be an authorization for the parties to bring a claim to the International Court of Justice, which would have jurisdiction as long as it is given in the establishing treaty, the foundational treaty. There are sometimes arbitral abilities. So we see this, for example, with the World Trade Organization. It creates its own entire dispute settlement body that is separate from the ICJ. But typically the pattern is to go to the International Court of Justice. There are, it should be pointed out, some proposals to use a primarily arbitral structure for the plastics treaty, but again, we'll talk about that more when we get there. And finally, there are the entry into force provisions. So this seems very simple at the end, and when you're done reading a treaty, you just kind of get to the end and go, okay, I want to be done. I know what all the obligations are. Let's move on. But this is actually really critical. So once a state signs a treaty and then it goes and it takes it home to ratify it, as soon as it's ratified that treaty term at home, it becomes part of the national law. And so obviously it has to comply at a domestic level with that national law. However, as I mentioned last time, there's a feeling that if we have 193 countries that are part of the UN system, and they all decide to sign a treaty, but then only two ratify it, it most likely shouldn't be a binding treaty because it most likely has very little power, since only two countries have ratified it. So typically what we see in entry into force provisions is the idea that we set a threshold, and once we hit that threshold number, for most MEAs, it's 50. So in the environmental context, it's typically 50 states that have ratified. The exception to this recently is the Biodiversity Beyond National Jurisdiction Agreement, the BB&J agreement, which is 60. But once we hit that number, then all the states that have ratified that treaty will be considered to be under international obligations as well. The treaty will be deemed to enter into force when that ratification has happened, when that 50th or 60th ratification has happened. And then the treaty is binding at the international law level. So, for example, the compliance committee options can start, the reporting options can start, all of these things can start. The conference of the parties will also be triggered, and typically will meet within 9 months to a year after that happens. So that date is really important because it also tells you when we start planning the COPs, when international obligations go into effect. So there are a number of different things that come out of it. And I always like to point it out because it tends to be overlooked since it is unfortunately placed at the end of a treaty usually. Just to run through a few things, I don't want to run over too much in terms of time. But how do we create a treaty? Typically, it doesn't come out of thin air. If it did, Shellen and I would not have spent so many hours together at various negotiation sessions over coffee and chocolate and coming up with ideas like these forms of boot camps. But usually what will happen is there will be an effort, for example, in the UNEP context, because we're talking about environmental treaties here, the creation of something like an open-ended working group or an exploratory group that looks into a particular issue. So it may be requested by UNEA itself, or the UNEP Director General may be empowered to take certain inquiry steps into a problem, a question. That can take several years, and it's really kind of trying to figure out what the situation is, what the groundwork already might be, what might be established, what might be needed, and then whether a treaty is actually needed or whether we would need something like a soft law instrument, like a set of guidelines or a further report, etc. If there is a feeling that there is enough of a need, as there was, for example, for the plastics treaty, to actually have a dedicated international instrument that will have binding elements, it will be a treaty, and it will be negotiated to create a future obligation, then usually whatever the decision-making body is for an organization, so in the UNEP context, it's the UN Environment Assembly, UNEA, will make a decision, and it will make a decision to authorize the meeting of a negotiating body, which will be made up of states. Typically, in practice, it also means an extension to observers, to non-state actors, although only states will be the ones who actually negotiate the terms and vote at the end. And it will typically also provide the parameters for what the treaty will be, what it will look like, what the scope is, at least is intended to be, and give instructions for those of us who are involved in the negotiations process for how we frame our work, what should come out of it. It can also, depending on the treaty timing and depending on the urgency, it can create a timeline. And it can create a timeline which says, for example, again, from plastics, within 2.5 years, you are intended to have negotiated a treaty. And so we authorize five meetings, 5 negotiating sessions for, oh my God, the autocorrect just said 55. Shellen, this is frightening. 55, no, 5.
We don't want 55 more
Only
meetings for
5.
plastic, please, no.
No. But whatever it is, the authorizing body has the power to say you have a limited time or a limited number of meetings to do this, or it can say you have a kind of an infinite period of time, depending. But since a number of treaty negotiations have taken a very long time recently, there is a trend to try to kind of rein this in a bit. And then if a treaty is successful, this is a bit of a kind of future-oriented discussion, but if a treaty is successful, and if the parties agree and we adopt a treaty, it doesn't just kind of sit there and go, okay, we're done. You know, 5.2, for example, as we'll talk about more. And if we adopt a treaty at the end, our work is not done. What has to happen is that treaty text has to go then typically back to the organization that authorized its negotiation for a check, and then that authorization from the organization will allow a diplomatic conference to be held. So very high level people, ministers, presidents, etc., prime ministers will come, will formally sign the treaty on behalf of their countries, typically make very high level statements. And at that point, countries then have the ability to take it home and ratify it. So they sign first typically, and then they ratify it later. And once that diplomatic conference has happened, then everything is open for signature and ratification. And at that point, we can say the treaty has been at least adopted, and it has been open for signature, and we see what happens next. We wait for the entry into force. So that is, I know, a great deal of information in a very short period of time. Just as a wee bit of a reminder, what we learned about in this session is background. So what international law is, etc. And then also today we learned what treaties are, the most kind of common elements in them, and what these elements mean, and then how negotiations are authorized and generally conducted. Now, we'll talk about a lot more in specifics about what it's like in a room when we get certainly to week 4 and we get to the really, really in-depth plastics negotiation discussions. And also when we talk about in the next 2 weeks, more granular elements of what different terms mean and how they're put into place. But this is just to give you a very general overview at the end of the week. So I will stop sharing my screen now because Shell and I actually learned how to do it. There you go. And I am happy to take questions if we have questions. I turn it back over to CYMG.
I guess we're getting pinned again for Q&A, but I also wanted to kind of leave off that point. Thank you, Kartik. We have another treaty negotiation potentially on the horizon, don't we?
We do. We do. We are assuming, and there is a general feeling that there will be mining and minerals related activity in the future for treaties. Now, I should also point out that, as much as the plastics treaty has become life for many of us, there is also an ongoing treaty negotiation process right now under WHO context for a pandemic treaty. And that also has been continued. So they also requested a little bit more time. And there are some other proposals for things on nuclear non-proliferation, etc. So there are a number of other issues on the horizon, but in the environmental context, certainly mining and minerals will be key, will be crucial in the future. And UNEP has already authorized and held, in fact, I participated in several years ago now, some ground laying work on what the state of these issues might be. So that has already been started, and I am assuming we'll continue to see more.
Awesome. And really, this is, I think a lot of us can testify that this is not stuff you learn in the regular classroom. A lot of us have law backgrounds and everything. So this is really, interesting information. And I think all of us are learning something. I also want to point out, just acknowledge before we get into questions, we have an amazing group of volunteers.
Yes, we do.
Jimena, Kartik, Timothy, let's see, make sure I get all here that that are all wonderful. Aishwarya, Clara, who are co-organizers. So it's not just us, there's so many of us. And they have graciously kept track of all your questions. So even though your aunt's asking the questions, they are actually putting in a document. So let's get started with the first one. And this is a really great question to start off with, because this is also a really big topic right now.
Yes.
Is the climate justice part of environmental agreements?
It can be. If it's present at all, it's often included in a preamble, at least at this point. But climate justice, especially when we think about the Paris Agreement, has been building off the idea of bringing litigation against states saying that they are not meeting their obligations under the Paris Agreement, and specifically looking at the nationally determined contributions that they have to file, that they've already filed, many filed as pre-filings in 2018, and then that they had to file again in 2023, well, 2020, and then had it assessed in 2023, and using those as justification for litigation. So saying you're not living up to A, your Paris Agreement commitments, and then B, your own commitments that you made in the nationally determined contributions that you yourself put into place. So the Friends of Irish Environment case from, I believe it's 2020, 2021, came out during the pandemic. That is one of those cases where we see a very successful litigation coming out of a nationally determined contribution and a claim about failing to live up to it. So that's typically where we see the nexus now. There are, I think, a lot of reservations about putting climate justice specifically into a treaty in more than preambular text, because there are some concerns that countries might look at it and say, all right, this is actually authorizing a lawsuit against us, and that's not the most popular thing. But there are certainly ways to use it, and it's a great question. Thank you.
Great, great. So the next question is treaty same as an agreement?
Yes, in the sense that they are all legally binding obligations. It is very much kind of splitting hairs at a certain point as to what each one means. But yes, it is functionally the same as an agreement.
Also, I just want to point out a question in the chat I think a lot of us can agree with. I could hear Alexandra for hours.
Oh God. Oh no, 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 no. There's a time limit for me. Okay, thank you, but no.
It's no secret though how passionate you are about the topic and how passionate
Yes,
a lot of us are about the topic. As we
yes,
keep pointing out, you're passing along this information to someday when you're on a beach,
yes,
retired in Mexico, we'll
yes.
be the ones doing the hard work you're doing.
And I will be applauding you and be very proud of you from that beach. Anyway.
So another question is, what are the different stages of procedures of negotiations?
So we have kind of the pre-negotiations. So we have, again, we'll use the plastics treaty because I think it's one that many of us are familiar with. It's also the newest one in this context, where you have the authorization of the negotiations themselves. Um, that leads to the creation of a secretariat for the negotiations, which we now do have. Then we have this question of, okay, wonderful. We have a secretariat, we have negotiations. How are they going to work? It's going to be on the table. What are the rules of procedure going to be? All these things. So typically there's an intersessional meeting, what we call an intersessional meeting, between when the authorization happens and then when the first negotiation session happens. So for plastics, this happened in Dakar in Senegal. I know we have some people from Senegal, so hi. Thank you. We will always remember Dakar for good reasons, including this. And that's where we had agreement on most aspects of the rules of procedure, not all, but most. And then basically a setting of the agenda. So we will have a meeting in November in one place, then the following year in two places, et cetera, et cetera. Once that all happens, then we move into the actual treaty negotiation process. And the first few rounds are typically very aspirational. They're very broad brush. I'm sorry, I need the coffee. Coffee. It's how I keep going. Once you typically get to like the second or third round, that's where you start to see actual text coming in. So for example, the first round, the INC one in Punta del Este in Uruguay, for plastics was really, I was looking back on my notes recently, was really just a lot of states coming together and making their points about why they thought the treaty was important, what needed to be included in it, what didn't need to be included in it, limitations, etc. And it was a very short one. And then we really got into more substantive work. And so by the end, you see that phase where we hopefully get to a final treaty text, and negotiate that out, and then obviously go into the diplomatic conference. But I think, Shellen, you will certainly agree with me that every negotiation round also has its own stages and its own momentum.
Absolutely.
Yeah.
And I think you can really see also the personality of member states. It's kind of like watching on TV. It
Yeah.
really is.
Oh, it is. It definitely is.
So there's a few questions similar for the next
Okay.
one, is that there's a lot of questions about what is the difference between COP and MOPS, and what is the interlinkage between COPs and MOPS?
I mean, horrible. The commonality is horrible acronyms, really very bad acronyms. But in addition, so a conference of the parties will always be the meeting of the actual, like the core treaty that establishes whatever it is. So the UN Framework Convention on Climate Change, the Convention on Biological Diversity, any of those treaties. That will always be the conference of the parties because they created this structure. anything that is subsequent to it, so the Paris Agreement or the Nagoya Protocol or the Kyoto Protocol for the CBD, or anything that is not that foundational document, will have a meeting of the parties. So it will be a MOP. Now, there are several reasons for this. First of all, the primacy is always given to the foundational document. Second, when we adopt a protocol or a subsequent agreement, so when we adopted the Paris Agreement or the Nagoya Protocol or the Kyoto Protocol or any others, the same states that are state parties and have ratified the underlying treaty, so the UN Framework Convention or the Convention on Biological Diversity, have the option of joining, but they don't have to. So you will sometimes see, for example, when the US previously left the Paris Agreement and presumably will again, you will sometimes see a situation where a state is a part of the Conference of the Parties because it is a foundational member of and has ratified the core text, so the UNFCCC, but it is not a member of the protocol or the subsequent agreement, so the Paris Agreement. And because it's not a conference of all the same parties together, it's called a meeting, which does have a slightly lower legal standard in international law. So technically, the conference of the parties is the highest, and then the meetings of the parties tend to be considered secondary to that conference. It's a very long way of explaining it.
Sometimes longer explanations are needed. I mean, this is a lot easier to explain than going to a negotiations and sitting down and then we're like, what the heck did I get into?
What is this? And then it gets even a bit more difficult to track when you're in something like the Basel, Rotterdam, and Stockholm conventions, because they are three separate conventions that all meet at the same time in a unified cup because they have a unified secretariat. And so you just try to keep track of which meeting is going on where, and it's an adventure. Anyway.
So next, this is still relevant, is what is the ministerial declaration?
So a ministerial declaration is it's a non-binding statement. It is typically an aspirational statement. It is a very high-level statement. So it is only signed by ministers or their equivalents or their authorized personnel from states that are authorized to be part of the process, negotiation process for a treaty. And it will talk about what all of the ministers who are in the rooms who could agree to think are, for example, core elements of a treaty moving forward, core understandings of what the treaty might be based on, and any other motivating elements. It does not have legal effect, but it often has a very high diplomatic persuasive effect. And it becomes part of what we call the background. Using, for those of you who do not speak French, I apologize. I usually try to just use vernacular whenever I can, but the official name being travaux préparatoires, which is also known in English as a working document. And that is an entire file of all the history of negotiations that A, is interesting for many researchers, but B, can be called upon if there is, for example, future litigation at the International Court of Justice as to what a term might have meant in the plastics context. Then it is possible for the litigants in the court to go back to the travaux préparatoires, look and see what's there, and if a ministerial declaration is there, it obviously can be used in that context too.
Amazing, amazing. So this is another great question. So we know that conference of parties, or COPs, as we commonly know them, the acronym, are really where we're allowed to make amendments to a treaty. They usually meet every 1 to 10 1 to 2 years, sometimes more. But are there any other organizations or bodies that are allowed to make amendments to treaties?
No, typically no. Now, sometimes there can be a very select like scientific committee that will come up with recommendations. So not typically in the environmental context, but for example, in the context of things like the International Maritime Organization, sometimes World Health Organization or Food and Agriculture, they have really specific bodies. So the Food and Agriculture Organization has the Codex Alimentarius, which is a classification of various types of agricultural products, food, etc. The World Health Organization has the International Health Regulations, which actually governed how we all handled the pandemic, although most of us never knew it at the time. And a lot of different shipping practices, so safety measures for the number of hulls you have to have on oil tankers, etc. These are all decided by very specialized committees within organizational structures. But even then, they have to be agreed to by the COP or its equivalent. So you have a lot of work being done in the background to do things that are essentially amendments because they change the way some operations happened. But they have to be ultimately done by the COP itself.
Awesome. Yes. If only if we could have them outside and make everything go by so much faster.
You know, but where would the fun be in that?
True, true. So another great question is, what is the difference between a ratification and a signature?
Excellent. I'm so glad. So signature is really easy. So a signature is a country, it'll happen at the diplomatic conference, and it will be either the prime minister or the president or a relevant minister who will come. There will be a great diplomatic fanfare, lots of photos taken, ceremonial pen, not like this one, but like a ceremonial pen, and a state will sign. And so that will mean that it signs in principle, right? It agrees in principle and it supports whatever the treaty regime is. But legally, it is not bound internationally just by signing. It becomes bound when it then says, great, we love this text, we've done all this work, we're taking it home and we're going to ratify it. And that is the process that is typically guided by a constitution, by each state's constitution. It will differ based on political system, legal system, many other issues. And even within, for example, a common law system, there will be many different views on how this has to happen between a country. But whatever, or between multiple countries, whatever the particular requirement is for that home state to ratify, it has to go through. So whether it has to go through one house of government and legislature or two, whether it has to go through, for example, some constitutional monarchies require the king or queen or monarch to formally introduce a bill for ratification, and then it has to go through legislative procedures. Once that happens, then a state is deemed to have ratified, and then it is legally bound under its own national laws as well as under international law once the treaty takes effect by whatever it has signed on to. But it is not, unfortunately, uncommon for states to sign treaties, to commit to them in theory, but then for a number of different domestic, often political reasons, not be able to do this at home and not be able to ratify, in which case they are not legally bound from the international law perspective by the terms of the treaty, unless that treaty also codifies something that is customary international law, like genocide, torture, slavery, piracy, etc.
And isn't it kind of your job right now to make sure that the treaty text, as part of the legally drafting group, to make sure the treaty text can be ratified into all
It,
these
it
100 and
is,
plus countries?
yes. So, the idea of the legal drafting group is to make sure that things make sense legally, and also to make sure that there aren't conflicting obligations. So we don't say in one article, you have to file a report every 5 years, and then in another article, so 7 years from now, you have to file your first report, and then have a bit of a gap.
Amazing. And I think these, I'm trying to combine with questions so we can have
Oh,
time.
great. Yeah.
I do think one thing that hasn't been discussed a lot, just not only in this, well, in this course it has, but overall, is that, how does the discussions and negotiations of open-ended working groups for the creation of a treaty, and how do you know if there's really this feeling for the need of a treaty?
So again, it's something where, you ideally the mandate includes civil society, includes observers so that they can be part as well. And there's always a reporting back period. There's always a reporting back to the UN General Assembly or to whatever the governing body is as to what the discussions include. And when we think about, for example, mining and minerals context or chemicals context, and these are some areas of real kind of up and coming focus, for example, the consultations that are held are typically quite open, in the sense that they're open to sometimes invite only, sometimes more broadly open, but they're open to not just states, but scientists, civil society members, lawyers, etc., trying to get an understanding of what the issues are. So rather than coming up with draft text that might go back to UNEA, typically the reports will have things like survey results. So I've completed a number of different surveys on different topics, and they'll ask for your expertise in certain areas. So if you're a lawyer, well, if you're me, certainly you're not answering all sorts of complex scientific questions. You shouldn't be, but you're answering the legal questions. There are some lawyers who can answer those, and they're wonderful, and they're great. They're not me. But it depends on what that insight is. And the idea there is you have these open-ended working groups. They are state-driven, but they include outside actors, and they try to just gather as much knowledge as possible. And they give that portfolio of knowledge to UNEA, which again is comprised of all the member states of the UNEP system. And they then have the ability to vote on whether or not to move something forward. So it's really a less political function and more of an information gathering function at the open-ended working group level. And then once we get to UNEA, that's where the decisions are made in terms of balancing the legal and political demands.
UNEA is very underrated in the news.
Oh,
It's
it is.
not like it should be more, because really, I was having this discussion with one of our social media leads yesterday as well. Like he didn't know really what's coming up, and it's the United Nations Environmental Assembly, which
Yes.
the next one will take place in December. And
Yeah.
you'll really be able to see some of the trends that are potentially on the horizon.
Oh, absolutely. Definitely. And it's always typically in Kenya. It's always in Nairobi, at UNEP headquarters. And it does give a really good perspective on both looking back. So at UNEA 6, and then obviously UNEA 5 was the authorization. UNEA 6 had a kind of midpoint stock take for the plastics treaty. And then we'll see, obviously, whatever happens as the outcome. We'll have a discussion at UNEA 7. They will issue some type of statement. So it looks back at what's been authorized before to see how it works in practice, but then also it's forward looking at the same time. So it will look at issues potentially like, mining and minerals or chemicals regulation, et cetera, and then figure out what we want those next steps to be.
Excellent, excellent. So I think this is another relevant question. There's been a lot of discussion about my own country, the United States. However, I am from California, so that's how I identify at this point. But how can an agreement protect itself from a country's sudden withdrawal due to change in the government of the signatory states, such as the Paris Climate Agreement and the United States, to prevent an agreement from losing its relevance due to the withdrawal from countries that initially ratified it? Excellent question.
It is a fantastic question. And the corollary is can we actually do it to prevent a state from leaving and then coming back and then leaving again, which is always a fun cycle. And this is really a balancing of the sovereignty of states with the kind of sacred nature of a treaty system. So you can't typically make a treaty that says a state cannot leave. It is not, to use a song reference that will age me, it is not the Hotel California. Okay. You really have to be able to check out and leave. That is a sovereignty requirement. But what you can do, and what many treaty regimes do, is structure it in a way that, okay, fine, you can say on January 1st, you're going to leave, but that cannot take effect for several years. So in most treaty regimes, just because you announce I'm going to leave on January 1st does not mean that by January 2nd you have left. it means that you have started a process, a cycle, and it will typically take several years before you can actually leave. So a treaty may say you have 1 year, or you have 3 years, or 5 years before your withdrawal becomes effective. In that time, you are still bound under international law to your commitment. So you still have to have reporting requirements fulfilled. You still have to meet all your obligations, etc. And during that time period, you can also be obviously brought to a compliance committee review if that is deemed appropriate as well. And unfortunately, that is the best balance we've come up with in terms of keeping states sovereign, which is obviously critical from the state perspective, and also trying to have some stability in the process. It's, it's halfway Hotel California. It's almost there, but it's really not. It's all we can do. And it should also be pointed out that when you make that announcement on, say, the 1st of January 2025, and let's say you do have a 3-year period before you're effectively gone, things like monetary assessments or amounts that you might owe as a state are also still there and still have to be paid. So you can't just say we're leaving and that's it. We give you no money.
Can't just say hasta la vista.
No, I mean, you try it, but you are theoretically under a legal obligation to pay your dues, etc. Yes.
Okay, we have so many great questions, and this has always been this is the second session. It's already been
I
so many
know
great
the questions are
questions.
fantastic, and I thank you all because it's so much fun. Like it really is.
I will leave you off with maybe more your opinion.
Oh dear.
By the final question, but make sure to come to our discussion session
Yes.
On Saturday. I know we tried to make it for all time zones. We can't necessarily, but we try our best.
We do, and we wanted to make sure that it had a specific time that would be hopefully decent, especially for those in the Pacific and in Oceania, because
Yeah.
we know you get left out a great deal. So we're trying as hard as we can.
Yes. And we know how involved your member states
Yes.
are in these treaty negotiations as well. So in your opinion, which components of treaty law are the most important to negotiate when helping other countries or delegates understand the treaty? From your experience, what are the most important things you have learned when it comes to negotiating with other people's parties or stakeholders?
Okay, we'll address the last one first. I think the most important thing I have learned is to really listen, right? To really listen to positions and think about why those positions are the way they are. Because it's very easy to sit in a negotiation room, know what you think should be in a treaty, know what you think would make sense. And then whenever you hear something that doesn't fit with that worldview, you just push back on it or you dismiss it. But that's not really going to help with a successful negotiation. A successful negotiation involves sitting there and going, okay, I don't agree with this, or at least I don't entirely agree with it. But why is that someone else's position? What are they afraid of? What is worrying them? What is motivating them? Why is that their position? And as soon as you start to think that way and you start to understand it, it doesn't even have to be a legal argument, but it helps you to understand where they're coming from and where their level of comfort might be and how you can work towards a negotiated compromise rather than just saying, okay, this needs to be this way and that's it. Which can be frustrating if you know that there is a better legal option out there. But when you're trying to figure out ways to get everyone to come together, it's a bigger motivation.
I feel like we've seen a lot of that
We
listening
have.
to the global South, especially.
So we really have. We definitely have. And it's a really important lens to think about. And then, I think in terms of what we really need to pay attention to, the control measures are obviously critical. Definitions are very helpful. And to the extent that we can have definitions, and if not definitions, things like principles. Because if we don't have a definition, but we can say that, or a definition section, but we say that there are principles we can draw upon, that gives us a good sense moving forward of predictability. And the idea isn't just to create a really, strict treaty structure. It's with definitions, it's also to give us an ability to predict and to legislate, and for businesses to be able to know what they can do and what they can't do. So it really does give us an important element of understanding. And then I think also it's really important to focus on the entry into force, so we know, is this realistically going to take a few years to hit, say, 50 countries? Or one of the proposals is almost 100 in the plastics negotiation context. That will be a great deal more. So that, I think, is something that we always forget about, but it's really important. And that's
I,
why I always train people on it.
I like this one comment I just want to say from Jimena, who said, I remember meeting a
Yeah,
member from the like-minded country that told me in a more informal that I don't agree with all what my country is asking for.
yeah,
I would like it to be stronger, but it can't go against what
yeah,
my country wants to come me representing them.
exactly.
And I think that's a huge lesson to also learn.
No, it is. And, and remember that negotiators are people. We're all people at the end of the day. And we're all, not there just able to do whatever we want or say whatever we want. And that's where that element of not looking at it as, an argument against me, but instead of two people having a discussion, finding what is motivating the other person, and then figuring out if you can create a pathway towards an understanding is always more critical.
Awesome. I mean, what a great way to end. And
It
we
is.
could go
Thank you
on
for the
for
question.
hours. So unfortunately, we do have to end. As much as we say we could talk for hours.
Yes.
Just a few reminders. We have the discussion on Saturday and about the time zone if you're in GMT or Europe. Feel free. I think we'll open up the chat for a bit since we have a few days
Okay.
between the sessions. So I know all you guys are chatterboxes. I think we're up to like over 800 people. And feel free to ask and
Yes,
don't
please.
afraid to reach out. We do get a lot of messages, so if I apologize if it's a little bit delayed, and that we're trying our best. So thank you so much, everyone, for coming. I mean, as I
Yes,
said before, we are blown away by the support. We would have been happy with 50 or 100. So,
absolutely. And please, keep asking questions. It's wonderful. It's fantastic. Thank you all. Really. Thank you.
and this will be up sooner than last time. So we'll see you hopefully on Saturday.
And take care, everyone. Be well. Thank you.
Bye.
Bye.